Before we even get into the judge's ruling, understand this. This case is not just about a fine, probation, or paperwork. It's about a woman standing at a crossroads between rehabilitation and complete collapse, which you're about to. Here's a courtroom moment where empathy, accountability, and hard consequences collide. The judge has already reviewed one of the most detailed PSI and TAP evaluations she's ever seen, digging into this defendant's life from childhood all the way to today. That tells us something important. The court is weighing who this person is, not just what she did, but here's the tension: deferred adjudication can be a second chance. Or it can be the last chance before prison becomes unavoidable. Add in the loss of custody of a child, a history of substance abuse, and the pressure of trying to rebuild a future with a criminal record. And suddenly, this hearing becomes much bigger than a routine plea deal. As you listen, ask yourself, is the system setting her up to succeed, or simply watching to see if she fails? And when the judge starts laying out conditions, employment limits, drug testing, restrictions involving minors, pay close attention. Because every condition tells a story about risk, responsibility, and how close this case really is to going the other direction.
All right, you can lower your hand, state your name for the record.
Brianna Butler.
All right, so if you were released from custody, who would you be staying with?
I'll be staying with my mother.
All right, and people will say that, but have you picked up the phone and called her and she wants you to stay with her?
Yes.
All right, now she's under oath. Okay.
After her, I want to tell you something about me and her mom.
Okay, all right, thanks. So do you have any children?
Yes, I have one son.
And what is his age?
His age is 2 years old.
And who does he live with?
He is not in my custody anymore.
Okay.
Yeah, I lost my rights.
Okay. And so what are your plans as far as employment? What are your hopes, your dreams, your goals?
My goals is to be a college graduate. I want to be a nurse, a RN.
Mm-hmm.
So when I get out, I do want to start school. I was already enrolling in the process, and then get a job.
All right. So what I can tell you is it's not impossible, but it's difficult. Anytime you have a criminal case, whether it's deferred or regular probation with a conviction, when you're seeking employment somewhere where it requires a license, it becomes more difficult. But it can be done, because I know someone who actually went to prison, and I know this because I work with them to try to get their license and everything. Guess what? They're now an attorney. So it can be done, but you just made it a struggle, okay? All right, did you all want to speak to the length of deferred adjudication? It's in the plea paperwork. And
this moment right here is critical. The judge isn't discouraging her dreams. She's warning her. When the court explains how a criminal case, even deferred adjudication, can impact professional licensing, especially in healthcare, that's not hypothetical. Nursing boards don't just look at whether you avoided conviction. They examine conduct. Deferred adjudication still leaves a paper trail, and it can trigger reviews, delays, or outright denials. But what's fascinating is the judge's example, someone who went to prison and later became an attorney. That's not leniency. That's perspective. The court is saying success is possible, but it will be harder because of choices already made. And notice how responsibility is being subtly shifted from the system to the defendant. The door isn't closed, but it's heavier to open now. So here's the question for you watching. Should courts factor future career impact into sentencing, or is that simply part of accountability? And if you were in her position, would you still chase that goal, knowing the uphill battle
adjudication?
ahead?
If you complete everything successfully, you can always approach the court for early termination. But for early termination, I'm going to be looking at whether or not you've been positive, whether you've been reporting on a regular basis. You understand?
Yeah.
So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, and I'll say 30 days of release.
Yes.
There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And they know unsupervised contact with minors, that can potentially change once you've shown me that you have everything, your life together. You understand?
Yes.
This will run concurrent with 718, 359, and 728, 369. Taking consideration NITMAC number 752, 652-760-865. Field visits 1 time per month for 6 months. 200 hours of community service. Says that she met the criteria for the MIC. So I'll do MIC. Let probation know. If you feel as though they're not a good case, always come back to the court. This is what I tell everybody. My goal is to be rehabilitated.
This is where the tone of the courtroom shifts sharply. We move from rehabilitation talk to real-world consequences. A probation violation tied to drug possession is not a minor slip, especially when the defendant is 7 months pregnant. The judge's reaction is direct and unmistakable. Drug use at this stage isn't just self-harm, it puts an unborn child at risk. And that elevates everything. And now the stakes multiply. The mention of SAP, CPS involvement, and the possibility that no one is present to take custody of the baby at birth. That's not theoretical. That's how family separation happens in real time. The court is laying out the roadmap of what will occur if safeguards aren't in place. Here's the uncomfortable question. At what point does compassion give way to protection of others, especially children? And should pregnancy result in more leniency or stricter oversight? This is the moment where accountability stops being abstract and becomes irreversible.
If you're out here in this world and you're having problems and you don't let them know, guess what? We don't know, and we can't help you. All right, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, and you want to tell me about her mom?
She and I are texting every day. She wants to know what happened now, today. So, yes, her mom's here.
All right, so they'll probably release you. It's probably going to be midnight. I have no control over
We
that.
have to make sure she's on bond in the 2 county court settings.
So if you make bond for that, this court is not the court that will be holding you. It'll be the misdemeanor court, okay?
Okay. Yes, sir.
All right, thank you.
Just had to talk to county court.
That's what will happen. You will have to do parenting classes and everything else that's required of you.
Violate condition number 1 on or about the 22nd day of May 2025 in Bear County, Texas. The defendant, Rayella Butler, committed the offense of possession of a controlled substance, plea group 1, in violation of condition number 1.
How many pleads to that? True or not true?
Yes.
What have you done?
I went to the 60 days NA or AA online virtual visits. I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. And how far along are you in your pregnancy?
7 months.
All right, so what that means is you're doing drugs.
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley. I have an affidavit that they brought in. Can I take my baby with me?
No, what ends up
This case
happening.
ultimately reflects the tightrope courts walk every day, balancing rehabilitation with public safety, compassion with responsibility. The judge made it clear, deferred adjudication is not freedom, it's structured opportunity. Every condition imposed, from substance monitoring to employment restrictions and parenting requirements, exists because the margin for error is gone. The denial of altered conditions signals the court's loss of confidence that lighter supervision would work. At this stage, the system isn't punishing potential, it's responding to repeated risk. And whether this defendant ultimately succeeds depends less on the court, and more on what happens when no one is watching. Now, we want to hear from you. Did the judge strike the right balance here, or should the court have taken a different approach? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.